Court does call the case of the people versus Christopher Day.
Good afternoon, Your Honor. Michael Doby for the people.
Good afternoon, Your Honor. Prosecute on behalf of Mr. Day is present to my right.
Your name?
Christopher D.
Hey, all right. All right. Date and time set for a preliminary examination. Are the parties ready to proceed?
We are, Your Honor.
All right. And I would just say that we had an in-chambers conference. There were some legal issues raised, and so the court may not finally rule on those today, but we'll take the testimony in the case. My understanding is that there's particularly an issue regarding the sheriff's department policies. I will take that testimony, and then this court can figure out if I ultimately determine that I cannot use it, then I won't. Additionally, if the court does determine that the policies won't be used as the basis for the misconduct, and I inform counsel of this, but can be used in order to, as some substantive evidence regarding the particulars of an element, particularly the corrupt nature of the actions, then the court may indeed take that testimony for that purpose. But so we can move this along. The court will hear the testimony and then make a decision later as to how it will be used.
Thank you, Your Honor.
All right.
With that, I would call Kurt Schifferkowski.
All right. Sir, please come forward and be sworn.
Thank you, sir. What do you do?
I'm manager of the Washington County Sheriff's Office.
And how long have you been in that position?
In that position since 2021.
Okay. And before that, what was your experience in law enforcement?
Started off at the Sheriff's Office in 2001. As a corrections officer, was a field training officer, was a sergeant in 04. Ran transport and court security. I was a lieutenant. Went through the police and corrections academies. Went to the MSA, special investigations. Did some work at the AG's office. And,
Thank you. I'm going to have some questions about incident in the jail, Washington County Jail, March 18th of 2024. Okay. Now, before I get to that, I suppose, do you know the defendant in this case? Christopher D.
Yes.
And how?
No, stipulate the identification and that he's a law enforcement officer in the employ of Washington County Sheriff's Department.
All right. Very
Appreciate
good. So
that.
stipulated.
We'll move along. Thank you, Mr. Gucher. When did you become aware of the incident in question here?
there was an email notification that was made at the time. D was a sergeant and he was working midnights, and I remember waking up and checking my emails the next day, and I saw an email notifying that there was a use of force in jail. Reviewed it. Things stuck out to me.
Tell me about that.
What immediately stuck out was that the email indicated that Sergeant D sprayed a subject in the back seat of a police vehicle, an empty police vehicle, while she was in restraints.
Okay. That stuck out to you. What did you do?
Notified one of the lieutenants that we need to evaluate the situation when it came to work.
Okay. And so why did that stick out to you?
So ASR spray is used when somebody is a threat, and because she was in restraints in the back of a police vehicle, bars over the window, I had concerns as to whether or not that person was a threat at the time of the incident.
Could you tell what is ASR?
Aerosol subject restraint, commonly known as MACE.
Okay. And is that something that is issued to officers in the jail?
It is, sir.
Okay. And are there trainings regarding that?
Yes, sir.
That are required?
Yes, sir.
And are there policies regarding that?
Yes, sir.
And are there, what is done, if anything, to make sure that the officers know about the policies?
Anytime there's a policy revision, or anytime there's a policy that's newly published, it's sent out in a program called Power DMS. The employees are required to review the policy and electronically sign, and yearly aerosol subject restraint. There's a training course that's pushed through Power DMS where the students have to participate in the training, watch a video, and take a test.
Okay.
Successfully pass the test.
It's specific to ASR?
Yes, sir.
Okay. Approach with people's proposed 4, 5, 6, and 7, which I've shown to Mr. Gucher. You mentioned that it's the incident that you were things stuck out to you because it was a use of ASR against someone who was handcuffed and in the back of a police car. Is that right?
Yes, sir.
And generally, from the what is your understanding from the policies of the proper use of ASR within the jail?
ASR isn't classified anywhere in the force continuum. It can be used anytime that the person that's applying force feels that lower forms of control will not be adequate.
Okay. Lower forms of control, what does that mean?
Muscling techniques, placing someone on the ground, escorting them.
Okay. Tell me about what you said, something about the individual not being a threat.
Yes.
Where does that fit in?
So ASR is used when there's a threat to staff or a threat to another person. And as the victim in the case was in restraints in the back of a police vehicle with bars on the window, it was difficult for me to see whether or not there was a threat to anybody else.
Okay. You talked about levels of clients using lower force to gain compliance. What does this mean, compliance?
To bring about a peaceful end to the situation, to bring about the lawful conclusion to an event.
Okay. When someone is, no, let's strike that. I'm not going to propose any hypotheticals there. Did you see, Commander, any justification for the use of ASR in that situation?
Objection relevance. Whether or not this officer sees that it's relevant is not the legal standard. Actually, under Graham v. Cards.
As to the form of the question, I'll sustain the objection. I'll allow you to rephrase the question, but I think as it's phrased, I think it's.
Thank you. In a situation like this, Commander Shipakasi, where someone is handcuffed and in the back of a vehicle, is that based on both your understanding of the policies and your own training and experience, a situation where ASR would be necessary?
Based on my training and experience, what I saw, no.
Okay. And why is that?
Because the person was not a threat at the time that ASR was used.
Okay. Talked about compliance. What was being asked of the arrestee at that point to comply with?
Answering questions as to whether or not she was suicidal.
Okay. What the 3 core questions that was referred to? What are the 3 core questions?
Use medical needs, you take medication, or anything thoughts of hurting yourself.
Okay. And what is the purpose of asking those questions?
Just gauging whether or not they're going to be suitable to enter the jail to have the full medical evaluation done.
Okay. And if
Also gauge whether or not we can place that person on the kind of observation.
and if someone does not answer those questions, what is done?
It's not unusual. We bring them into the facility, search them, possibly place them on precautions depending on the situation.
Okay.
Cross-examinations.
Commander, briefly, were you going to get the individual out of the car?
I'm sorry, sir.
Were you going to get this individual question out of the car?
No, sir, I wasn't there.
Okay, so you weren't there, but you determined that there was no threat to the officers that were, correct?
Based on the circumstances.
Okay, were her feet restrained?
No,
What direction were her feet facing while the sergeant was talking to her?
I'm not sure.
Okay, well, if the feet were facing the officer, could that be a threat?
Not, no, because she was in the back of
Okay,
the vehicle.
is that where she was going to be housed?
No,
Okay, so what do the officers have to do to house her?
move her from the vehicle.
Okay, so if they open the door and the feet are facing the officer and they're unrestrained, is that a threat?
No, that's typically how we get people out of the vehicle.
So you're telling me that it's not a problem for officers to be kicked?
No, I said that's how we usually get people out of the vehicle.
Right, but that wasn't my question. is that a threat to have the feet unrestrained at an officer?
Depends on the circumstance.
Okay. So did you see the demeanor of the individual that was coming into the jail?
I did.
She was kicking the back of the windows of the car.
When she was on the way there, yes.
She was screaming, yelling, insultive, combative.
Yes,
Okay. The officers have to make the determination to get her out of that car, right? How they're going to do it?
yes, sir.
Now, the three questions were just a precursor to getting her out of the car, correct?
Yes, sir.
The officers were actually there to extricate her from the car and put her in a cell.
Yes, sir.
Okay. Sergeant D or Day and one other person, what was the other sergeant that was present? Do you recall?
I believe it was Sergeant Merritt.
They're the ones that are in charge of getting this individual out of the car,
Yes,
correct?
sir.
The other sergeant was a female officer, is that correct?
No, sir.
No? Were there female officers present?
Yes, sir.
And that was in part because not only do they work in the jail and handle all other prisoners, as a policy and procedure, you guys have female officers when available, deal with female.
When available.
Is that correct? And again, the ASR doesn't appear on the chart because you said that, I want to get this quote right, not part of the continuum because it can be used anytime the officer feels or believes. And what was the rest?
Performance of control not be adequate.
Okay. No further questions.
All right, thank you. Any redirect?
One question, Commander Shipakasi, based on both the policies and your training and experience, is the preemptive use of ASR spray reasonable?
Given the circumstances, no.
Okay, thank you.
Yeah. You may step out. Thank you, Commander.
Oh, Brian Miller.
All right. Sir, please come forward to be sworn. All right, you may inquire.
And what do you do, sir?
Currently, I'm a special investigator with the Washington County Sheriff's Office.
How long have you been doing that?
Since 2009.
Okay, and briefly, you have law enforcement experience before that?
Yes, I've been a certified law enforcement officer since 1974.
Okay, thank you. I asked some questions about an incident in the Washtenaw County Jail on March 18th of 2024, okay? How did you become involved in that?
I received a phone call from Commander Shipakasi stating that there was the incident that took place on March 18th in the Sallyport Correctional Facility at approximately 20 feet, 30 hours, involving WCSO personnel and an arrestee from the Atlanta Police Department.
Okay, and was that arrestee Rachel Dameron Hissong?
Correct.
Okay. So you got this notification from the commander, and what did you do?
I was instructed that they had some concerns, they being the administration, of whether or not the use of force was appropriate in this particular case.
Okay,
And, I was instructed to conduct a non-administrative investigation.
criminal investigation.
Correct.
Okay, and did you do that?
Yes, I did.
Okay, and you could walk us through a little bit about the steps that you took in this investigation.
Well, one of the things I did was I had a liaison with the corrections division, a lieutenant that I asked to assist in some of the technical aspects of the investigative process by gleaning information from audio and video information that existed in a series of cameras. Initially, information from the Sallyport, then it was information from the body cams worn by Sergeant D and Sergeant Merritt, as well as information from the cameras in the holding cell, as well as information of the activity that took place.
Okay,
That was the first step.
Your Honor, I'll stipulate to the admission of I believe we discussed body cam of Sergeant Day and the in-car camera from the point in time it reaches the Sallyport, the Washtenaw County Jail to the end of this incident, correct?
yes.
Yes, stipulate.
All right.
Thank you. That will be People's Exhibits 1 and 2. Mr. Miller, you obtained a number of videos,
That's correct.
and People's Exhibit number 1, which has been admitted by stipulation, is going to be the body cam of the defendant. And if you will give me a moment to connect.
You just cracked the window. Hey, Rachel. Hey, my name's Sergeant D. I'm the supervisor that's on shift right now, along with Sergeant Merrick, okay? Hey, so I want to get you in, but I want to work with you. I don't want to, I do. I want to work with you.
So let's just be honest.
So I get paid whether you're here or not.
Whatever.
All right, so here's the thing. I want to get you in the door. And we are having a conversation right now. No, we're not going that way. Are you suicidal? Are you suicidal? I'm asking questions. Are you suicidal?
Yes or no, are you going to respect?
I have been treating you.
Yes.
So,
Simple motherfucking question.
are you suicidal? Yes, I'm going to treat you with respect. Are you suicidal? Yes or no?
My question.
Do you have any emergency medical needs?
Yes or no?
I have been. Rachel, I'm trying to help you out.
Answer yes or no.
So here's what I'm gonna tell you.
Still not answering the question. Literally, all you have to do is answer.
I'm trying to get you taken care of, and I'm trying to work with you.
I'm asking you, are you going to treat me with this?
Do you have any meaning? I've already told you yes.
Yes.
This is the last time I'm telling
Am
you.
I going to treat you with human?
Never.
Shut up.
Right now. Stand up. Go down to your knees. Lay down your stuff.
I'm going to stop the play there. We're at 23, 36, and 34 seconds on the timestamp of People's Exhibit 1, the Sergeant D's video. That was one of the videos that you obtained.
Yes, it was.
Okay. And reviewed.
Yes.
And what did you do after reviewing that video? Oh, I didn't mean to start playing again. I'm sorry. Commander let me start that over. That was a terrible question. Commander Shipakasi talked about things sticking out to him. What sticks out to you in that video?
Objection, Your Honor, relevance at this point in time. He did the investigation. His opinion of what the investigation shows is irrelevant.
Oh, overruled. Oh,
What sticks out to you?
Well, a number of things. And you talked about, as qualified by saying, one of the things I did in my career was a chief use of force instructor, as well as a ASR instructor. And so when I looked at the actions and the interactions involved in this interaction between Sergeant D and Ms. Hissom, I felt that it was problematic in terms of the actions taken by Sergeant D.
Okay, what do you mean problematic?
The use of ASR is for someone that's non-compliant. Okay, and what I mean by non-compliant is that you've given them a directive, told them something specifically to do, afford them a reasonable period of time to comply with that. Okay, and you also give them a warning that if they don't comply with that there will be consequences, and subsequent to that, the ASR will be deployed. What I saw here was none of that took place. There was no warning given. There was no directive given. In terms of a threat to Sergeant D or anyone else, she was confined in the backseat of a patrol car, handcuffed behind her back, in a particular patrol car that has cages all the way around. What I mean by all the way around, both the side windows between the passenger compartment and the rear window were all caged in. And when we talk about imminent threat, okay, she was not posing at that time. She did not exhibit any aggressive, threatening behaviors that would necessitate the use of the ASR, nor was a warning given to her deployed with two other police officers in the front seat of the car. That's what was problematic for me.
But you heard her yelling at the officer and insulting him, right? You said that she wasn't doing anything.
So when we talk about ASR, what we're talking about is you want to gain compliance. Okay. Well, you have to have a directive to gain compliance. Okay, asking questions is not the same as giving a directive as I want you to do this. I want you to do that. We are getting ready to open the door. I want you to step out of the vehicle. Okay, none of that was given.
Okay. Tell me a bit about ASR itself, and you've talked about when it is appropriate to use, but what is the effect of it?
Well, it's basically a combination of like CS gas agent, a chemical agent that creates an irritant. Okay, so it momentarily incapacitates a person that will afford you the opportunity to take control of a person, and you hope that they will comply based on the fact of this irritant that has been applied to them.
Okay. Pain, right? It causes pain?
Absolute pain compliance.
Okay. What are the other considerations around ASR and the use of ASR that you were a trainer in? What are the other considerations?
Would you actually deploy it? In this case, it was deployed inside the confines of a occupied police car. And I say occupied, above and beyond the subject, Ms. Hissom was occupied by two fellow police officers in the Atlanta Police Department. And again, what I found to be problematic is that there was no warning given, so that they were equally being sprayed as well as Ms. Hissom in the confines of the car.
Cross-examination.
Special Investigator Miller, you're aware of the policies and procedures, at least in general.
This case hits like a straight-up clash between authority and accountability, where a law enforcement officer, Christopher Daya, finds himself on the hot seat not for chasing criminals, but for what he did inside the jail. And from the very first moment, the courtroom tension makes it clear that this isn't just about policy, it's about power, control, and whether that power was abused. The entire case revolves around one explosive moment: a restrained female detainee locked in the back of a police vehicle, handcuffed, contained, and already under control, yet still sprayed directly in the face with ASR pepper spray by Sergeant Dia. Now here's where things get serious. The prosecution builds its case around a simple but powerful argument. There was no threat, no command given, no warning issued, and no justification for escalating force to that level. The detainee was loud, yes, yelling, insulting, and uncooperative, but being disrespectful is not a crime that justifies chemical force, especially when the person is already restrained and physically contained. Testimony from senior officers and investigators only adds fuel to the fire. They describe the use of ASR as problematic, emphasizing that it's meant for gaining compliance only after clear directives and warnings are given. Not as a first move, not as a shortcut, and definitely not as a reaction to attitude. Even more damaging is the fact that the spray was deployed inside a confined patrol car, exposing not just the detainee but also other officers to the chemical effects, something that clearly goes against basic safety principles. The prosecution paints a picture of a misuse of authority, arguing that this wasn't a split-second life or death decision, but a deliberate act and unnecessary escalation that crossed the line into assault with a dangerous weapon and misconduct. In office, but then comes the defense, and they come in strong, pushing back hard against every accusation. Their argument flips the entire narrative. This wasn't abuse, this was discretion. They lean heavily on the idea that law enforcement officers are trained and trusted to make real-time decisions in unpredictable situations, and that the law, especially cases like Graham v. Connor, gives them broad latitude to act without being judged unfairly in hindsight. According to them, the detainee wasn't just loud, she was combative, kicking and unpredictable, and the officer had every reason to believe that removing her from the vehicle could turn dangerous in seconds. They argue that ASR isn't even classified strictly within the traditional use of force continuum, meaning its use is flexible and based on officer judgment, not rigid steps. From their perspective, the spray wasn't punishment, it was prevention, a calculated move to safely extract a potentially violent detainee without risking injury to officers. They also attack the prosecution's legal framing, arguing that pepper spray doesn't automatically qualify as a dangerous weapon capable of causing serious harm or death, and without that classification, the entire felony charge starts to fall apart. On the misconduct charge, they double down, saying there's no evidence of corrupt intent, no proof of malice, no sign of perversion or abuse of power, just a decision that others might disagree with, but disagreement alone doesn't make it criminal. And this is where the judge steps in, cutting through both sides, asking the real question: where do we draw the line? If officers have discretion, how far does it go? Can force be used preemptively based on what might happen, or only in response to what is happening? Because if this action is justified, then what stops any officer from using force on any restrained individual just because they might become a threat? That question hangs heavy over the entire case, exposing the core conflict. This isn't just about one spray, one detainee, or one officer. It's about defining the boundary between lawful authority and unlawful force. In the end, no final decision is made, yet the judge adjourns the case, wanting more time to review the evidence, the law, and the arguments, leaving everything hanging in suspense. And that's what makes this case so intense. It's not clear-cut. It's not black and white. It's a legal battlefield where every word, every action, and every interpretation matters. One side says this was an abuse of power. The other says it was a justified decision under pressure. And now, everything depends on where the court decides that line truly exists. If you want more real courtroom breakdowns like this raw, intense, and straight to the point, make sure you like, subscribe, and turn on notifications, because the next case might push the limits even further, and trust me, you don't want to miss it.